You can't show up to the Super Bowl not prepared for the Super Bowl. This is the big leagues, and you have to bring your A game. Another fumble for BONJEAN.
That takes us to the second case on our argument calendar, United States versus Kelly. All right, and is it Ms. BONJEAN or BONJEAN? How do you pronounce your name?
BONJEAN.
BONJEAN. All right, Ms. BONJEAN, you have reserved 3 minutes for rebuttal, so that gives you 7 minutes out of the gate.
Thank you.
You may proceed.
May it please the court, my name is Jennifer BONJEAN and I represent Robert Kelly. Like every RICO indictment seemingly in history, the government charged the defendant with being the member of an enterprise that had a common purpose of carrying out an illegal or illicit activity.
Well, I guess I'm trying to understand, are you challenging the jury instruction, which didn't say that the RICO enterprise had to have an illegal purpose?
No, Your Honor, I'm not challenging the jury instruction, nor could the jury instruction be challenged. The jury instruction is entirely consistent with United States versus Boyle. In fact, it's almost word for word the same jury instruction. And in Boyle, as this court may recall, where the enterprise or the instruction was challenged, even though it wasn't set out with specificity what the structure of the enterprise should be, the Boyle court said that's fine. It doesn't have to be. The jury doesn't have to be instructed with that level of specificity. In this case,
but you're arguing, it seems to me, that absent an illegal purpose, there can be no RICO enterprise.
Yes, because it would make nonsense of the statute.
Okay, but is it so? I guess A, what's the authority for that, and B, isn't that really a challenge to the jury instruction?
I don't believe it is. I think that.
Well, did the district court tell the jury that they had to find an illegal purpose so there could be no enterprise?
No, but the indictment did, and the indictment was incorporated.
No, the indictment listed a series of purposes.
Yes, series of purposes pled in the conjunctive, and the jury instruction, which had the indictment incorporated into it, pled that there were 4 different purposes, 2 of which were legal essentially, and 2 which were illegal.
All right, but I'm asking a basic question to start, which is that if the government had just listed the legal purposes, your view is that that would not be sufficient for a RICO indictment?
No, in fact, district courts routinely dismiss complaints that do not demonstrate that the purpose of the common or the enterprise is illegal in nature. In fact, neither party's been able to find a single case where the purpose of the enterprise was entirely
You're arguing that there was insufficient evidence here to prove an illegal purpose?
Correct, or illicit or fraudulent or some type of
Wasn't there substantial evidence?
No, Your Honor, I respectfully disagree. There was substantial evidence of.
Please finish.
Yes, there was substantial evidence, perhaps, of defendant's wrongdoing in the context or using "quote unquote" the machinery of his organization, his entourage, those types of individuals. But there was very little evidence, almost. And certainly not sufficient to meet the government's burden of proof, that any of those individuals acted with this common purpose to, quote, recruit women for Mr. Kelly for illegal sexual activity or for the production of child pornography.
So I'd like to just make sure I understand. It sounds to me as though you're making a legal argument that a RICO enterprise has to have an illegal purpose, as well as that here an illegal purpose was charged, but there was insufficient evidence of it.
Yes, Your Honor,
right?
That's correct. That is precisely right.
And I want to understand, in light of Turquette, why we have to find an illegal purpose as well. I mean, there's language in Satinwood, and most of the cases that have been cited and discussed are in the context of a fraudulent purpose that may have some legitimate enterprise around it, but there's room for confusion there. But Turquette seems to say quite directly that the term enterprise as used in RICO encompasses both legitimate and illegitimate enterprises. So maybe you could help me.
Yes, the issue isn't whether it was a legitimate organization, a legal entity versus a non-legal entity. Turquette held, and the question before Turquette was the exact opposite. whether a RICO enterprise could be exclusively criminal, not whether it could be exclusively legal. And our position is that this was an organization that the government failed to prove had any criminal purpose. The government takes the position that for a RICO enterprise to exist, it need not be rooted in criminality at all, which would fly in the face of Turquette, frankly. Turquette looked at Congress's intent, both the statement of...
Didn't the government prove that one of the purposes of this enterprise was to recruit girls so that Kelly could have illegal sexual activity with them?
They pled it, they did not prove it. What they did prove is that through the course of a period of time, there were perhaps efforts to pass along information, a phone number, to invite someone backstage. There was no evidence presented that any of those individuals did so believing or knowing that someone was underage, that you go to a big concert, there are 17, 18, 19-year-olds. Even the victims themselves said, well, nobody asked me for my age. When the age came about, perhaps Mr. Kelly may have known, and that's what I think some of the women testified to, but there was no evidence that anyone went out there saying, may I find out what your age is? Are you underage? Come back. We want to serve you up to Mr. Kelly. That just didn't happen. And in fact, there is extraordinary evidence that the members of the enterprise, again, these are some of the people, I guess, that testified, repeatedly made it clear that what happened behind closed doors was not something they understood. Yes, there were rules and things they did, these anodyne tasks that were perhaps a little unusual, but not that put them on notice that what was happening behind closed doors was illegal. And we are talking about matters that happen behind closed doors. The fact that a video recorder existed in a bedroom does not ipso facto make it evidence that there is child pornography.
You're saying these other individuals didn't know that these girls were underage? That's
exactly what I'm saying. I think the evidence that was presented to the jury was deficient in that regard. There was so much excessive evidence, frankly, about Mr. Kelly's wrongdoing that it would be easy to be tempted to go down the path. Well, everybody must have known, but that is just not what was demonstrated at trial. And
the appearance of these girls would be evidence enough, wouldn't it?
These were not 12-year-olds. These were not 13-year-olds. There were some example. What was testified to is that some of them looked young. And having multiple teenagers myself, looking young does not mean you know someone is a minor. And the question becomes, did they have an obligation to ask? Did they have to do due diligence, do inquiry? When he said just go pick somebody up, again, just using individuals, unwitting individuals, who perhaps even turned a blind eye or who didn't inquire further, does not a RICO enterprise exist. And I would leave with this point that simply speaking, I mean, I won't leave with it, but the law presumes in Turquette, which was an entirely criminal enterprise. They weren't speaking to the question of whether it could be a legal enterprise with a one man doing illegal acts in the context of the enterprise and using his employees. So Turquette does not, from where we stand, put this issue to rest. And what the government wants to do is simply read out of the statute organized crime. And at the end of the day,
They want to read out organized crime? What are you saying?
Yes, because the purpose of the statute, the RICO statute, is to address organized crime. Now,
it's not in the text, though, right? When you say read it out, right?
The definition of organized crime is not in the text of the statute. And in fact, courts have universally read organized crime very liberally, very broadly. And we're not quarreling with that. But you can't just have an organization that is not associated with any crime. Simply speaking, a RICO enterprise is a criminal organization. You can define it broadly, but is not an organization simply with a criminal. And that is what the government is asking the court to find here. I believe my time has expired.
But I mean, you're not challenging the jury instruction. So you're agreeing that everything the district court told the jury they needed to find was correct, right?
Your Honor, the jury instructions were consistent with every jury instruction ever given in a RICO case, historically. and frankly is consistent with what the United States Supreme Court held in Boyle.
Right.
I don't know how.
So the jury wasn't asked to read out portions of the statute. The
Again, I go
jury was
back-
correctly instructed. And so I guess I'm trying to figure out. You're saying that the evidence didn't support the elements that were correctly instructed to the jury.
What I am saying, Your Honor, is that the government had an obligation, and in fact, the jury was instructed that the government had to prove the theory of the enterprise. The theory of the enterprise included criminal conduct that was pled in the conjunctive. And if it had been just simply legal activity pled in that indictment, it would have been dismissed. Because routinely, again, and we cite numerous cases, as does the government, district courts simply do not allow RICO prosecutions or RICO suits to move forward where you don't have an actual fraud or illegal or illicit activity that is the moving force or that is the common purpose. This would be outside the realm of, again, contrary to the purpose.
Back on the issue of whether the staff knew the age, sometimes the staff booked the travel arrangements for them, and therefore they had to have identification documents. Isn't that evidence that they knew they were underage?
I think if you look closely at the record, you will see that the government was very clever, frankly, of conflating these issues where I do not believe there was any evidence that a employee booked travel for someone who was in fact under the age of consent. So you have to remember in Illinois, the age of consent is 17. It only becomes a federal crime if it's being videotaped. Now, do these people know what's happening in the bedroom? No, there is no evidence that
Wasn't there evidence that the staff made sure that in his backpack he had his iPad and recording equipment? The evidence doesn't show that?
It shows that people picked up his luggage. I mean, people pick up my luggage. I pick up other people's luggage. Am I responsible for what's in that luggage? It just takes this to the point of absurdity. We can't say an enterprise exists because unwitting employees are engaging in normal tasks that they do, particularly for high profile people.
Thank you.
Thank you.
Ms. Bensing?